whole House is greatly in the debt of the noble and learned Lord Goldsmith, for giving us the opportunity today to debate the Rwanda Agreement, to consider the nature of our international obligations, and to make the judgment that the noble Baroness Lady Bennet just referred to on whether Rwanda is a safe place in which we are able to send asylum seekers to. I serve, along with the noble Lord Delakia and the noble Baroness Lady Lawrence, who are in their places, as one of 6 members of your Lordship's House on the 12-member strong Joint Committee on Human Rights under the admirable chairmanship of the Edinburgh Member of Parliament, Joanna Cherry MP. And I note another of our members, Baroness Kennedy of the Shores, is also in your Lordship's chamber. We were in session again last Wednesday, taking evidence from the Refugee Council, from Justice, the Immigration Law Practitioners Association, Chatham House, Migration Watch, and Professors Sarah Singer and Tom Hickman KC. Among others, on Wednesday of this week, we'll hear from Lord Sumption and indeed from the noble Lord Sandhurst KC, who spoke earlier in our debate. My Lords, it's the job of Parliament to hear different views and to carefully assess the arguments. And too often, as my noble friend Lord Hannay has indicated earlier, we put the cart before the horse. We don't do it. It isn't good governance. And too often we pass legislation in haste and we repent at leisure. And this treaty before us, but also the bill that will come, and also the one that we have already considered in 2023, the Illegal Migration Act, are all examples of that. In the 5,000-word report that the JCHR produced on that act, we said this bill breaches a number of the UK's international human rights obligations and risks breaching others. We went on to say that this gives us considerable cause for concern. And we said the government is rightly concerned about the loss of life in the Channel, and so are we, echoing the point that the noble Lord Howell of Guildford, of course, made trenchantly in his speech. The loss of life and the scale of the migration crisis is such that politicians of all persuasions must respond to the widespread concern and anger at the failure to tackle the crisis, both here and in other jurisdictions. But it doesn't do the process any good when we are seen to stampede things through both houses. And, my Lords, I would simply note that when the Joint Committee asked the then Home Secretary, Suella Braverman, to appear before us to justify the measures that were in the previous bill, she declined to do so. I do not believe that is the way that Parliament should be treated. I don't think it does anything for public confidence in our processes. The government rightly insists that the criminal mafia-like gangs who make their fortunes by preying on the desperation and misery of the vulnerable must be hunted down and jailed, and I agree. And I also commend and agree with the government that they've achieved a great deal in their bilateral agreement with Albania and the progress made towards a pan-European initiative at the European Political Community Summit of 47 European leaders in Grenada last October. But, my Lord, perhaps the Minister will tell us, is it really the case that the EPC will not meet again until June? My Lords, this requires urgent international strategy and urgent decisions. Our Joint Committee on Human Rights report was insistent that the global crisis of displacement, and the UNHCR now puts that number at 110 million people, meant that, and I quote from our report, given the sheer scale of this global crisis, it cannot be solved by one country alone. And recall, my Lords, that 8 out of 10 refugees, many millions, end up in neighbouring countries, not in the United Kingdom. So there are plenty of other countries who need to join an international alliance and promote an international strategy. 2 years ago, on January the 6th, 2022, on behalf of my noble friends on the crossbenches, I moved a motion which noted, I quote, that 82.4 million people are displaced worldwide, 42% of whom are children, and 32% of whom are refugees, and 2, the case for an urgent international response to address the root causes of mass displacement. That was 2 years ago, 82 million, and the number is now 110 million, and that number, my Lords, will go on rising. Unless we tackle the fundamental reasons for displacement, the tsunami of desperate people will continue to be washed up on Europe's shores and indeed its seabeds. 9 months since I chaired an inquiry into the situation in Sudan, we've seen 7 million people in Sudan alone who have been displaced. In Darfur, 500,000 people now in Chad, just over the recent weeks. Add to that the numbers from Tigray, or from Eritrea, a tiny country, and yet 500,000 people are now displaced from that country, escaping the cruel conditions that prevail there. The JCHR was told last week, and I quote, that unless there is a collective global effort to create stability through conflict resolution and the promotion of rights in those countries, the number of refugees from those specific countries is unlikely to decrease. It was Winston Churchill who promoted so much that we now take for granted, including the European Convention on Human Rights. He rightly believed that such international architecture, based on the rule of law, democracy, human rights, security and economic recovery, represented our best hope for the future. Which brings us directly to the Noble and Learned Lord's motion and what Parliament is being asked to agree. As we have been reminded, it was the unanimous decision of the Supreme Court in November, based on the identification of a number of concerns about Rwanda, including poor compliance with its international obligations, poor understanding of the Refugee Convention, and a poor human rights record, which led to the International Agreements Committee producing the report that we've been considering. And of course that report actually says this: the Rwandan government does not possess the practical ability to fulfil its assurances to the UK government, at least in the short term. That is not something that can be fixed by entering a binding treatment alone. And to confirm that, last week the JCHR heard evidence of the inadequate in-country access to legal remedies in Rwanda, a lack of independence of the judiciary and legal representatives, and a bad track record in complying with other international agreements. And then let me turn finally to the issue and central issue of safety. Once again, we have the Home Secretary unable to give a Section 19(1)b statement on the face of the bill to affirm that the compliance of the bill that's coming before us next week is present, which can only presumably mean that they don't regard Rwanda to be a safe destination. Witnesses to the JCHR last week put it to us that if the government was confident about the safety of Reformor, they wouldn't be afraid of independent judicial oversight. The question today is simply whether we can honestly say that Rwanda is a safe country, and it was put to the JCHR that this also engages the separation of powers between judiciary and parliament, a point which was made by the Noble and Learned Lord, Lord Goldsmith, earlier. Professor Singer said this: to contradict the Supreme Court in this way is perhaps not showing the respect to the court that should be owed as a constitutional principle. Furthermore, the legislation prohibits the UK courts from reopening and considering the question of whether Rwanda is safe. The JCHR was left in no doubt that if this bill is rushed through the courts, will once again be asked to decide whether Rwanda is safe and whether circumstances have changed. And guess what? If the verdict is that Rwanda is still not safe, the law will have to be changed yet again. And meanwhile, the government of Rwanda itself has said they wouldn't want, as the Noble Lord, Lord Razzle reminded us, they wouldn't want to implement a scheme said to be contrary to international law. In considering the issue of safety, the House will want to take into account the new analysis of the UNHCR published last week, in which it once again insisted that Rwanda is not a safe country, a point which was made by the Noble Baroness Lady Lister. That says this: it includes the following. As of January 2024, UNHCR has not observed changes in the practice of asylum adjudication that would overcome the concerns set out in its 2022 analysis and in the detailed evidence presented to the Supreme Court. At a minimum, my lords, the government needs to tell us what has changed on the ground in Rwanda since the Supreme Court decision. What evidence does it have, for instance, in regard to political oppression or to LGBT people? What examination has the government made of the reasons why Burundi has closed its borders with Rwanda, and that country's Rwanda's links with the M23 militias in the eastern DRC. What analysis has been made of that? And what is its response to the 2023 Human Rights Watch report that commentators, journalists, opposition activists and others speaking out on current affairs and criticising public policies in Rwanda continue to face abusive prosecutions, enforced disappearances and have at times died under unexplained circumstances? Now, like others, my lords, I visited Rwanda, in my case in the aftermath of the genocide, and saw terrible mass graves. Huge strides have been made to recover from the deaths of between 500,000 and 800,000 people, as my noble friend Lord Carr reminded us earlier on. But it's deceptive to describe Rwanda as a safe country for refoulement, and it's passing strange that we have 5 alleged genocidaires living in the UK that we've not sent back to Rwanda for fear that they would be at real risk of not receiving a fair trial if they were returned there. The primary issue in those extradition proceedings was whether they are at real risk of a flagrant denial of justice if returned to Rwanda. They expressed fears that they would be tortured and executed. When the cases came back in 2015 and 17 to the courts, this is what Lord Justice Irwin and Mr Justice Foskett said in their comment. Our concerns focus on the political pressures on the judicial system, the independence of the judges, the difficulties and fears of witnesses, and particularly the capacity of defendants of allegations of genocide to obtain and present evidence and be adequately represented in their defence. My lords, we should think very carefully before stampeding through treaties, agreements, or indeed next week new legislation. I don't believe that public concerns about migration will be assuaged by offloading, as my noble friend Lord Carr said earlier on, offloading our responsibility. It would clearly allay many public concerns if we were more efficient in dealing with applications, more swiftly and sorting out the genuine from the false. But instead of this, we're told we must make a Faustian pact and trade our commitment to international law and the safety of asylum seekers in return for measures that even their supporters say will not work. For all those reasons, my lord, I will vote for both of the motions that the noble and learned Lord has placed before the House tonight, and I hope the rest of the House will too.